We see these stories all the time. A homeowner gets into a fight with their HOA. But this one ended so fast it'll make your head spin. And hidden inside that abrupt ending is a huge lesson for literally anyone living in a neighborhood with an HOA. So let's get into it. This thing right here, this is a final order. It's the official document that just slammed the door shut on a homeowner's case against their HOA. There was no big courtroom showdown, no long, drawn-out battle. It just stopped. And we're going to figure out exactly why. So that's the million-dollar question, right? What on earth went so wrong that a case could get tossed out before it even got off the ground? It's kind of like a mini mystery, and all the clues we need are right here in the paperwork. All right, so let's meet the players. On one side, you've got the homeowners, Barry and Sandra Saxion. They had a problem with their HOA, the Silverton II Homeowners Association, so they filed an official petition. But the HOA, well, they had a plan to shut the whole thing down immediately. So the HOA's lawyers didn't even bother arguing about the original complaint. Nope. Instead, they used a legal tool called a motion for summary judgment, which basically means they walked up to the judge and said, hey, listen, based on a couple of really important technicalities, this case has no business being in your courtroom. And their whole argument, their entire strategy to get this case thrown out, it all boiled down to just 2 points. That's it. 2 simple objections they thought would make the entire lawsuit just disappear. Let's take them one by one. Okay, so here are their 2 big arguments. First, they said the wrong person was suing. And second, they said the homeowners completely skipped a step they were required to take. Pretty straightforward, right? But incredibly powerful. All right, let's dig into that first objection. This all comes down to a legal idea called standing. So, what is legal standing? Well, it's actually pretty simple. It just means you have to be personally and directly affected by something to sue over it. You need to have some skin in the game. It's a basic rule to stop people from filing lawsuits about things that don't concern them. So the HOA's lawyers pointed out that Barry Saxion's name was on the petition, but plot twist, he wasn't technically a property owner in the community. Their logic was simple. No ownership, no standing, case closed. And you gotta admit, that seems like a solid point. But not so fast. The judge took a closer look and noticed that Sandra Saxion had also signed the petition. And guess what? She was a property owner. So since at least one of them was a legit owner, she absolutely had standing to bring the case. And just like that, bam, the HOA's first argument gets shot down. The judge recommended denying their motion, so the homeowners won round 1. It feels like things are going their way, and the case is about to move forward, right? Wrong. Because that second objection, man, that was the knockout punch. And it all came down to the fine print in the HOA's own rulebook. See, every HOA has these things called governing documents, or CC&Rs. And you need to understand, when you buy a house there, you are signing a legally binding contract that says you will follow every single one of these rules. They aren't suggestions. They're the law of the land for that neighborhood. And there it is, the smoking gun. The judge pulled this exact text straight from the HOA's own rules. It says that any and all claims must go through the HOA's internal process instead of just filing a lawsuit. It couldn't be any clearer. So the rules the homeowners had agreed to laid out a very clear path. Step 1 was mandatory. Use the internal process. But what did they do? They skipped right over step 1 and went straight to step 2, something the rules explicitly told them not to do first. So when the judge saw this clear-as-day violation of a contract the homeowners themselves had agreed to, well, there was really only one possible outcome. The judge recommended the entire petition be dismissed, and the reason had nothing to do with who was right or wrong in the original argument. It was simply because the plain text of the rules said you have to do this first, and they didn't. They broke the rules of the game. And look how fast everything fell apart after that. On the very same day the judge made the recommendation, the hearing was canceled. Just 2 weeks later, the final order came through. Case closed. It was over. So why are we digging all this up? Because this isn't just a story about one family's legal troubles. It's a critical lesson for anyone who lives in an HOA right now or is even thinking about it. So what's the big takeaway here? Number 1, your HOA rulebook is not a friendly guide. It's a contract, and it's legally binding. Number 2, you have to follow the dispute process it lays out, to the letter. If you don't, your case could get thrown out before anyone even hears your side. That fine print has some serious teeth. And that brings us to the final and most important question. And this isn't for them, it's for you. Before you ever get into a disagreement, do you actually know what's written down in your HOA's rulebook? Because as this case proves, what you don't know can absolutely bring your fight to a dead stop.